will be discussed today. We will define seaworthiness, cargoworthiness, obligation of ship owners, obligation by owners to exercise due diligence, documentary seaworthiness, cargoworthiness violation examples, and also the rights of charterers. Let's first define what do we mean by seaworthiness here. The vessel to be in such a condition as to allow her to carry the cargo safely from the agreed load port to the agreed discharge port. So the ship must be satisfactorily equipped, bunkered for the intended voyage. This is what we mean by seaworthiness here. Also, seaworthiness include the condition of the hull, the state of her machinery, and also cargo spaces to be ready to receive the agreed cargo, and also the competency of her officers and crew. Also, seaworthiness include documentary seaworthiness here. So a vessel will not be a seaworthy if not carrying documents required by the law of her flag, by her class, by the laws, regulations, or by the local authorities here, or any documents required under the charter party. Also, the ship owner and the master, they have due diligence to make the ship seaworthy. All charter party requires due diligence to have been exercised by ship owners before and at the beginning of the voyage to make the ship seaworthy. Also, it is an obligation of the ship owner as per Hague-Fisby rules to act reasonably in relation to her to make the ship in a seaworthy condition. It is also stated in the charter party that the owner shall keep the vessel in a seaworthy condition. Also, sometimes it's not spelled out, but it's an implied warranty by law to make the ship seaworthy by the ship owner, as per Hague-Fisby rules requirement. As an example here, we have GenCon 2022 form here in voyage chartering. The owner has an obligation to exercise due diligence to make the ship seaworthy. Also, as you can see in number 2 here, at the commencement of each cargo carrying voyage be seaworthy and properly manned, equipped, and supplied. Same as in time chartering NYPE, the master and the ship owner, they have an obligation to make the ship seaworthy. As you can see in this line, the number B here, the vessel on delivery shall be seaworthy and in every way fit to be employed for the intended service. Otherwise, if this is not satisfied, so the ship can be off hire here. The same as shell time 4, maybe it is not expressly stated seaworthy, but it's an implied here. The ship owner and the master, they have an obligation to make the ship seaworthy and they have due diligence to make the ship seaworthy. What are the consequences of unseaworthiness of the ship here? If the ship is unseaworthy, the charterer can claim damage or compensation for any loss suffered. For example, maybe he can be liable here if cargo damaged from not watertight hatches or cargo holds here. The charterer also, in some cases, he can terminate the charter party, or in time chartering, charterer can put the ship off hire. Regarding the right to terminate the charter party, the charterer is not always entitled to terminate the charter party in the event of unseaworthiness being found. So we have some condition here. Termination of the charter party is often restricted to situations where the unseaworthiness can frustrate the commercial use of the cargo. It means that the charterer cannot load his cargo, so there is no contract. If he cannot load his cargo safely, it means there is no seaworthiness here and it's a violation of the contract. So meaning charterer would not be able to load his cargo safely from the load port to the discharge port. It means he can terminate the contract and sometimes he can claim for compensation. Let's discuss cargoworthiness here. What do we mean by cargoworthiness? The vessel shall be suitable to load the intended cargo, whether it is bulk or liquid or tankers here. So the ship must be suitable to load the intended cargo. The ship must be properly cleaned as required to load the agreed particular cargo here. So cargoworthiness, it relates to the fitness of the vessel for the reception of the particular agreed cargo in the contract. So the absence of such fitness is described as unseaworthiness here in this situation. So cargoworthiness is a separate aspect of seaworthiness here. So seaworthiness, it means the ship is seaworthy, the ship can travel from port A to port B. But cargoworthiness here, maybe the ship will not be able to carry that particular cargo. So it depends on the cargo itself. Cargoworthiness, it means the intended cargo should be carried according to the contract. Regarding cargoworthiness violation, examples like the smell, for example, from fumigation, which can spoil cargo like grain or other food stuff. Maybe a temperature should be maintained for refrigerated cargo. If that temperature is not maintained, it means the ship is not seaworthy or no cargoworthiness in this condition. So a tanker also carrying dirty cargo cannot carry clean cargo product without a considerable amount of cleaning. And cleaning, of course, tanks, pipelines, and pumps must be cleaned between each voyage. So the charterer can refuse the ship or may claim for compensation in these situations here. Thank you for watching this short video.